So with that, before we get going, anybody have any strikes or continuances?
Yes, sir.
Go ahead.
Bodish, guardianship of Bodish.
Yes.
In Your Honor, on this one, we're asking for a short continuance. I believe we have reached an agreement. We just need time for me to get my client's written consent and to do the finding and order.
Okay. Anybody else have anything on that?
Amy Powers for the children in this matter. I think that is correct. I know I represent 2 children. Madison is in agreement. I haven't had an opportunity to touch base with Tristan. He's currently in juvie, so it's going to take me a little bit of time to get in contact with him. But if we could set this over 2 weeks, I'm optimistic we can have a final agreement.
Your Honor, if I may, the state's not currently involved, but the children are receiving TANF with their guardian. I just want to confirm with the parties that they're looking at an agreement for a full guardianship.
Return of one of the children and then full guardianship for, limited guardianship because there's visitation for the other child.
Okay, then the state would need to file a notice of appearance on this to handle the child support portion of the guardianship that would be in place.
Okay. All right. Anybody else? All right. Hearing no one.
My apologies, my audio didn't turn on quickly enough. This is the matter of the Royer children.
Okay, hold on, please. Anybody else on the Bodish matter? Okay, hearing none, I'll go ahead and set the matter over 2 weeks then. So we are looking at, let's see, well, can't do that. That's July 4th. So do you want to go over to the 11th, July 11th?
That's fine with me, Your Honor.
Okay.
That's fine with me.
Okay. All right. So we'll go ahead and set it over to July 11th at 10:30.
Thank
yes,
you.
Your Honor.
Thank you.
We need
Thank
a
you.
set over of at least a week. Ms. Farr and I are still working on making sure we can get the final orders. It appears that there is not a disclosure form that's been filed. And then I just want to clarify with the court, Ms. Farr is looking for a corrected proof of service on the father, Kevin Royer, on the 21st of November, 2023. There was a proof of mailing served with the court. I just want to confirm that that will suffice as the proof of service. And if we need anything else, we need time. We need to set over to correct the issue.
You said what date?
On November 21st, 2023.
So on November 2nd, I have an Indian child welfare proof of mailing.
And that was the issue, was that it was filed as an ICWA notice and not as a proof of service. So the court had said to refile it correctly as a proof of showing it was proof of service.
Yes, that's what I'm saying as ICWA. So that would need to be corrected. So with that, it seems like maybe 2 weeks is July 4th, so that's not going to work. So I'm wondering if you want to go over to the 11th. That way you can make sure to wrap up everything.
Yes, Your Honor, that would work.
Okay. Anybody else?
That works, Your Honor.
Okay.
That works for the state as well.
Okay.
Thank you.
Thank you, Your Honor.
This is a review hearing for the final guardian ad litem review and updates on progress of counseling. Who do I have present on that matter?
Respondent mother, Marlene Melton.
Christine Dow representing Guardian Jamie West.
Guardian Jamie West is here.
The guardian ad litem, Amy Turnbull.
All right, and just so you know, Ms. Dow, I'm having a hard time hearing you. So just to let you know that.
I'll speak slowly. There's construction going on in the background, so I've got volumes down.
Okay.
That-
All right, so we'll just see how we do here. All right, so we have the review hearing for the final guardian litem report. So where do we stand on that, Ms. Turnbull?
I'm asking for a continuance. The counseling was a little bit delayed in getting started. The parties just started, I believe, on May 31st. They've had, I believe, 3 sessions.
3 or 4.
3 or 4 sessions. And so I'm just getting started connecting with the provider in terms of getting some feedback. So I'd like to get that feedback to be able to incorporate into the report. So if we could maybe set this over, I believe you said July 4th unavailable, so the following week, which I believe is 3 weeks.
July 11th.
July 11th.
So everyone okay with that idea? Any objections?
No.
No
No.
objection. We wanted to just, I spoke with my client about this, and we wanted to just clarify something about when we're going to start the week on, week off. My client has asked that the child remain with her until the 30th, which is next week, so that he can do his next counseling appointment. And then as we move forward with this week on, week off with Ms. Melton, she can just bring the child to his counseling appointments on Wednesdays.
I agree with that.
Anyone object to that? I wasn't sure who said I agree.
Oh, that's me. I'm sorry.
Okay.
Mom. Ms. Melton.
Yes.
Okay. So, Ms. West,
Yes.
your thoughts?
No, that was what I was thinking would work the best.
Okay.
Because he gets out of school on the 25th, and then his very next appointment would be the 26th. So.
Okay. Ms. Turnbull?
I'm in agreement with that.
Okay. All right. Anybody else that I missed? All right, hearing no objections, that sounds like the good thing to do. Ms. Dow, can you reduce that to an order just so that it's real clear? And it can be a pretty simple order, just to make sure the dates are correct.
Yes, I will work off of the previous order if that's okay. And I'll just update it.
Sounds good.
All right, thank you.
All right. Apparently there's a review hearing already set for July 18. Do you want to just go to the 18th rather than have 2 in a row?
Yep, that's fine. That works.
That's
Okay.
fine.
Okay. All right. So let's just do that. I'll strike the 11th and we'll just go to the 18th. Okay.
Okay, thank you.
All right, thank you, Anna.
Thank you.
All right, and this is a request by Dad for more time, and also a contempt matter.
Your Honor, I think there's 2 different. The motion to address the visitation is the GAL's motion, and I think contempt is sent for a different date.
Okay. Yeah, I thank you. I actually recalled that after I said that I think it's set for a week or 2 out. So with that, disregard the contempt matter. Let's just address that one matter. Before I get started, who all do we have here? Okay.
Hannah Cowden for petitioners. And if I may say something before we begin after everyone
That's
has
fine. Wait, I see Katrina Force, and anyone else on this?
No, Lisa. for Katrina Vorse, Your Honor.
Okay.
Jack Carnahan for father.
All right, Ms. Cowden, go ahead.
Yes, Your Honor, before we get started, I will note for the court that my withdrawal has been filed. And while I have advised against this for my client, I've been informed by my client that they would like to represent themselves in today's hearing, as opposed to have me speak on their behalf.
Okay. All right, Mr. and Mrs. Force, is that correct? That's your understanding?
That is correct.
All right. You're going to need to turn your volume up just a bit. I'm not sure what's...
I don't know. I can talk a little louder.
There, that's better. If you talk louder, that works better. Okay. All right, so this is a request by Dad, but I don't see Mr. Anagnostou, and I don't recall.
This is the GAL's motion, Your Honor, not Dad's motion.
Oh, I still don't see Mr. Anagnostou.
He is not present. He is out of the country. He was aware of the hearing and was going to attempt to have somebody represent him, but he indicated no objection to moving forward without him.
Okay. All right. Ms. Day, go ahead.
Thank you, Your Honor. I appreciate it. Sorry for all the confusion back and forth. So this is my motion because of my concerns about the petitioner's continual interference in the visitation with father and refusing to engage in any kind of contact or response to visitation with mother. So in regards to father first, Mr. Vorse, petitioner, unilaterally decided not to have a visit last week based on his own decision in contrary to the order that you had put in place. I reached out to Mr. Vorse and to his attorney, attempted to try to resolve the matter, and was met with just simple refusal. They believe that he believes he does not have to follow the order and that he has the right to protect Jessica, superseding your order and the written orders of the court and father's right to visitation. My contention in this matter is very simply, Jessica has a right to visits with her parents. And my role in this matter is to help protect that right and to support her and make sure that that happens. Jessica's had 3 visits. The visits went very, very well. She's readdressing and rebuilding that bond she has with father. Father is doing an excellent job in entertaining her and engaging with her at her level and in providing and demonstrating appropriate parenting responses. To interrupt the visits unilaterally is not only a violation of the court order, but it is detrimental to Jessica. She has 3 visits. She just is getting into the swing of things, and Mr. Vorse decides to stop the visitation. He indicated in the email he sent he was refusing to do the visit because he was not provided a UA. I have provided all the documentation to his attorney as soon as I can get it. And sometimes there is a delay because it takes time to get that information from the treatment center to myself, get him processed and faxed over to everybody and served with the court. But he has remained in compliance and I've provided proof of that. And when the concern was raised, I've checked on that. When we moved forward and I tried to provide that information, Mr. Vorse just simply refuses. That brings us forward to no visit, and Jessica, again, is interrupted. Her contact with her parents is interrupted. When this week's visitation came around, again, Mr. Vorse refused to do the visitation under the same grounds. And after some back and forth with him and his attorney, the visit did finally happen on Tuesday. There was some discussion about how that was supposed to happen. And that was made arrangements with Miss Leanne Couch to supervise the visit, but this will be the last time she's able to supervise. She showed up for the visit that was missed from Tootle without any ability to supervise the visit. It didn't happen. So she did make herself available this week, but I believe this will be her last week to supervise the visits. Based on Dad's ability to manage Jessica, the bond that's rebuilding, Jessica's comfortability, and the demonstrated recovery time, I think it's appropriate for the visits to move forward. I think they should move forward monitored at the community house. I think that's perfectly appropriate. Dad has shown levels. But most importantly, Your Honor, I'm asking for you to please provide direct instruction to the petitioners that they do not have the right to supersede your order. Now, I do want to address their response. In the response I received, there was a new allegation that Miss Couch had indicated she was concerned father was under the influence. And I spoke directly with Miss Couch about that the day of the missed visits and the day that that declaration came out. So first I'll say that information was never provided or presented before, or it could have been addressed the day of. I believe it's just disingenuous on Mr. Vorse's part by presenting that for this hearing. There was no discussion of that, no report of that by anybody to anyone, including Miss Couch, who I spoke with after the visitation that she supervised before the missed visit. Mr. Carnahan has remained in compliance. He has not, that I can determine, been actively using anything. All of his UAs have come back clean. He's in treatment. He's going to meetings. He's doing parenting classes, and he's attending all the visits and complying with the court's orders. Only person not complying right now is Mr. Vorse. And I need the court to please secure Jessica's right to visitation with her parents and help move this process forward so that Jessica can hopefully be successfully reunited with her parents. And then my second request is just that you would order some set visitation times for mother. Mother has graduated treatment inpatient. She's provided clean UAs. She's been accepted with the CHESS program, and so she has secure housing. And I provided that information under sealed for your honor to review, as well as to the other parties. And so rather than having to bring another motion, I'm asking that we can do this both at the same time, if you would. And that's all I have.
So, Mr. Esau, anything from you?
Just a couple of things, Your Honor. We would join in the motion to allow visitation with Katrina Vorse, the mother. She has completed treatment. It was it was inpatient treatment, and she graduated, I think, a day early or something of that nature. But she's done a great job. She's provided clean UAs. Previous visitation was for an hour and a half until she got caught up on some missed visitations back in January because of delay that we brought before the court at that time. And then it was previously for an hour. So my client would at least want to have at least an hour every week. I'm not sure where that will take place or who will supervise at this point, but I think that those visitations should restart. If she hasn't made up all the time for the missed visits in January, then I'd ask for an hour and a half until she gets those taken care of. Yeah, that's all I have to offer at this time.
So before I hear from Mr. and Mrs. Vorse, I want to speak to the idea in regard to the request for the mother's visitation. This is, I commend the mother for the work that she's done, and this is not to minimize that. But the problem that I see on these minor guardianships is too much is done without a notice, without filed documents. So I will not be considering it's not properly before the court. And that creates issues of what's actually going on and what's before the court. I understand, Ms. Day, where you're at and your request. At the same time, I would ask that it simply be noted up. Shortened time, you can do a motion for shortened time and get it on next week is fine. But at this point, I would like to see it actually noted up and properly before the court.
Your Honor, I did include that in my motion.
Let me go back and look at your motion then. I thought you had indicated you had not.
No, I did include, I wrapped it up into it because I had gotten notice that she was graduating.
Okay, I misunderstood you then.
I apologize.
Okay, with that, then I'll go ahead and entertain it.
Thank you, Your Honor.
All right, so Mr. Vorse, I'll hear from you first.
All right.
Okay, I can't hear you hardly at all.
In the effort to be totally transparent, we have spent over $12,000 for all money and alternative.
Mr. Vorse, I'm having a really hard time understanding you and hearing you. So
can you hear me now if I talk like
yes,
this?
yes.
In the effort to be totally transparent, Carla and I are 65 and 67 years old. We spent over $12,000 and several hundred of clothes and cribs and food and doctor's appointments. So that's why the attorney, we just can't.
Mr. Vorse, every time you look down, you just go into silence or minimal sound.
Okay.
I don't know if the others are having troubles. Maybe it's here, but I'm only hearing a small portion of what you're saying.
Okay, is it better now? Wish I knew
Yes.
where the microphone is on this. Anyway, we spent over $12,000 in attorney fees, and we've also several hundreds of thousands of dollars really on cribs and clothes and everything else. So at 67 and 65, it's just not affordable to keep an attorney on. I will say that concerning why we didn't go to Visitation specific is request. So I've been working with Washington State, with Congress on the Keeping Families Bill, the 1227, and then the changes in 6109. Both confirm in Section 102, Paragraph 4, that paramount consideration for the court shall be the health, welfare, and safety of the child. Our history, just to tell you where we're coming from when we decide what we're deciding. Katrina Vorse called us to pick up Jessica last November because of.
Okay, we're gonna have to do something different. You're going in and out. I can't hear you. I don't know if you're just using a computer's sound system or what, but it's not coming through.
I can't hear anything, Your Honor.
Yeah, I think he's still working on it.
Okay.
Okay, is that better?
Yes.
Okay. All right. So I've been working with Washington State Congress on the House Bill 1227, a Keeping Families Bill Together bill, and we recently passed modification 6109, which confirms in Section 102, Paragraph 4, that the paramount consideration for court shall be the health, welfare, and safety of the child. Now, I'll give a little history. Katrina called us on November 6th because the police were there to come pick Jessica up. It was in the pouring down rain, and she was just wearing a diaper. We obtained this 168-page from Peace Health. This is 2 years of medical history for Jessica. In that time, she had 2 broken arms, multiple cases of MRSA, multiple abscesses, and several other medical problems. We've also obtained the criminal records for Jack Carnahan, where over 40 times in the last 11 years, he was arrested or confronted with police on different offenses, 40 times in 11 years. So, on one of those investigations, included pictures that the sheriff took inside of this black plastic wrapped home that Jack called home, with Jessica's clothes and diapers and baby formula next to drugs and drug paraphernalia. They were there investigating the charges of a fentanyl pill being found in her mouth, and the charges of child neglect for Jack Carnahan came out of that. Now, under the advice of Dr. Canada, who has been her primary pediatrician physician since birth, we took Jessica to Progress Center to be tested, and Jack and Katie had been asked this multiple times in those 2 years. We took her and they found her to be behind in cognitive and communication skills, and because some of her behaviors that were noticed, they referred us to a child trauma specialist, Patricia Anderson. Now, Patricia Anderson, her February.
Hold on, Mr. Vorse.
Yeah.
Mr. Esau.
Yes, Your Honor. I have to object at this point. I mean, this is not responsive to the motion for visitation with Jack Carnahan. We're getting into testimony about the ultimate facts in this case, and therefore if we could have him just address the issues of visitation, we all understand why we're here, and we don't need to go into things that have already been established through the documentation in the case. So I'm objecting to any further discussion of the background and ask that the petitioners address the guardian ad litem's motion for visitation.
So, Mr. Force, I would just ask that you bring it back. I understand the nature of why it's here. I understand the allegations and what you've said and the evidence that you're talking about. I would just ask that I understand all that. So let's narrow it down to what it is that Ms. Day is requesting at this time. What is your concern now?
Okay, according to the order, even the last order, the guardians are responsible for the physical and mental health of the minor. And so regarding this, when I'm talking about what things that Dr. Canada said, or that now trauma specialist Ms. Anderson said, this goes for why we say that this is against the order, because this is one of the aspects that we're responsible for her mental health. In her February 13th report, she said there are reported behaviors of our concern that this child has experienced trauma. I hope that this will be taken into consideration and determining next steps for living arrangement for Jessica. She also advised me while I was there against having any visits with parents at this time in her life. Maybe later, but not now. I did text from her office during that visit. I texted the Guardian Atlanta team today this information. On May 16th, the court ordered visitation. That's when you actually ordered visitation. And in this order, it says that conditions for visitation shall have visitation providing a clean UA to his attorney or petitioner, with the UA to be conducted regularly, allow review for continued compliance as will be required for visits to continue. If the results of the UA show that use of any substance not prescribed legally by a doctor show up as positive, including marijuana levels rising upwards at any point, levels above 5.1 of May 15th, although that was collected on May 8th, visitation shall not continue. It also states in there that Leanne will serve as the supervisor. During the last hearing, Clerk Agnoster and Guardian Litem both said during that hearing that Jack Carnahan goes to 2 different treatments and he gets a UA every week, so there's no need for hardship or providing another one. They would forward as soon as they get them. Now, after 5 months of not hearing anything from Jack Carnahan, they submitted to us an email of UAs for Jack Carnahan most every week in April showed methamphetamine use. And so we also received for weeks 429, 52, and 58. After that, we received just a drug screen that showed no levels at all. And lastly, a report from Core Health on June 12th that simply states month of May compliance with no UA. Now, I called Core Health SUD supervisor, Ashley Bowers, and I just asked, do you do random or do you do regular UA? And she said, no, we do not. It is totally random. So now we're left to say that this self-confessed said this, and it's that motion filed that he's been a drug addict most of his adult life. And so I don't know if he's coming clean or not. In fact, on April 17th, he tested positive for fentanyl. Now, I am concerned that there might be fentanyl on his clothes when he picks up this little girl and holds him. So, on May 21st, the first visit we had with Guardian Ad Litem, she was overheard telling Jessica to go give, referring to Jack Carnahan, a hug goodbye. Now, when there was strong evidence that she was abused sexually underneath the care of Katrina and Jack Carnahan. On May 29th, visitation was without the agreed supervisor and only the Guardian Ad Litem, which is in direct violation of your order as well. After the June 4th visit, we asked the court appointed Leanne Couch how Jack Carnahan looked, since we have not seen the UA since May 8th, almost a month. She said his eyes looked funny and that she would be contacting the GAL King today. On my follow-up call with this 13-year drug counselor, she was told by Tina Day that the medication he is on makes his eyes look like that. As of today, the GAL has not asked us, the guardians of over 7+ months now, how Jessica was after any of the visits, which is reasonable response by this, it's another RCW, which says that to determine the minor's best interest, to the extent known, or that can be reasonably ascertained by the guardian. On May 16th, at court hearing, also the guardian has the power over healthcare decisions, including mental health. Since these visitations have begun, we have noticed these changes. She was mostly potty trained, even going poop on the toilet, and now she just cries when she's sitting in. She was talking so much better, even singing her ABCs, her whole ABCs, and now she's back to often mumbling, grunting, pointing instead of talking clearly. This is how she was when we got her back in November. She was going to sleep every night, just laying down and going to sleep, and now she mostly cries when we lay her down and wakes up during the nighttime screaming, standing up in the back of her crib, screaming, no, no. And a lot of times she wakes up. Now, in fact, this last Tuesday, we took her to visitation, and that night, which she normally goes to bed at 8:30, and she lay there awake, crying and sobbing, even though we're in the room, until 11:30 at night. And she woke up many times during the night, and a lot of times just saying, Nana, are you still there? She normally loves daycare. And now they have called us twice just this last week to come pick her up because she doesn't participate. She just lays there by herself. I'm not saying this happens all the time. This has been happening since the visitation. RCW 11-130-230 says, does hold a minor guardian accountable and act in the child's best interest, including 2A says, including physical and mental health. I just have a brief summary and I'm done here. We have known Jack Carnahan for over 10 years and Katrina her whole life. They have been heavy drug users the last several years, resulting in many criminal activities and many medical problems for Jessica. The court ordered regular UAs, which were provided beginning the end of March until May 8th for a total of 7 in a row, and then they just stopped. All of April's tests were positive for methamphetamine through April 17th, and even tested positive on April 17th on that day as well. Now, no explanation was given to us why they were stopped, or even though the court ordered that they were required them, and the GL and defense attorney told this court that they would be being done every week and would be provided. Additionally, when the trained supervisor told GL about unusual symptoms, she dismissed her experience observation. According to the original court order on 11-4 and continuing as president, we guardians by order are responsible to do what's best for Jessica, including mental health. Jessica's physician from birth repeatedly reported how poorly Jessica was doing, noting failure to thrive in almost every report, and how well Jessica is doing under our care. Additionally, trauma expert said in her report, Jessica will thrive on routine and structure as well as appropriate expectations from nurturing adults. I might add that Jessica has not had one broken arm, not one abscess, and not one MRSA since we've had it. No one, including the GAL, has asked us about how Jessica was handling the visitation. Simply stated, oh, this program. Jessica has regressed and is an emotional mess most of the time. This was voluntarily reported to the GAL, who dismissed our experience and demanded immediate compliance with visitation. That's all I have.
So, Mrs. Force, you are also a petitioner. Anything you wanted to say?
That is all going on. And over the last month, she has regressed so much that she usually just yells at us. She mumbles like she did when we first got her. And she's afraid she's gonna be left. Like you said, she'll wake up in the middle of the night to see if we're still there with her. And I am concerned about whether or not they're on drugs when they come, because we haven't seen anything. But when she calls, well, over the last 4 weeks, there's been those visitations, and every night it's worse, every night. And it's hard to watch that movie over your friend like that.
Ms. Day?
Yes, Your Honor. It was very hard for me to hear. It sounded like mostly mumbling, so I will do my best to respond and keep it as brief as possible. I first want to say that I appreciate all the work that the divorces have done, but they have, by their own choosing, spent the money and taken the steps to help Jessica, and I appreciate that. And I'm sure the parents do as well. But I want to be clear about a couple of things. I have read through those medical records. I've spoke with Progress Center, read their records. I've spoke at length with Tricia Anderson, including this week. And there is no evidence to suggest that Jessica was abused. And I want that to be clear. There is no evidence of that. The only information that any of the providers have comes directly from the petitioners. Yes, I believe Jessica has suffered trauma. She's been in less than stellar conditions while she was living with her parents. She was removed from her parents, and she is very young and has a difficult time, as any toddler would, understanding why she was taken from her primary caregivers in her primary living arrangement to a totally different location, and then not had any contact with her parents for more than 6 months. I think that that's important. And I think the court is very well aware that children often go through difficult emotions, including regression and acting out, when they restart visits or begin the transition home or transition all the way home. That is not uncommon. And that is not indicative that something terrible is happening to this beautiful young girl. I've seen her at visits. I have sat through those visits, and she is articulate. She is able to advocate for herself. She speaks very well. She behaves. She plays. She acts like any other toddler that I have ever seen when I see her with her father. I have also seen her with the petitioners when I was there doing the home visit, and with Progress Center there. And she is very much making great progress. She is no longer needing services from Progress Center. She's no longer needing counseling from Ms. Anderson. And I think it's important for the court to understand this child has a legal right to her parents. If they can maintain their recovery and move forward, they have a right to their child, and their child has a right to their parents. And I think that that's most important. Jessica has a right to a relationship with her parents, and these are her parents. Nothing that I see going on currently would tell me that there's any inherent risk to Jessica than there has ever been to any child who have parents who suffer from addiction. They suffer from addiction, and they're finally taking those steps, and I commend them for it. I don't think we're in a place to rush to judgment and return this child, but I do think that we have to make it very clear that Jessica's rights have to be the most important. Her rights, her needs, and her ability to develop those relationships unhampered by anybody. She has a right to that. I, again, just ask the court to order the visits to occur, that the petitioners not intervene in those visits and violate the court order, and that the court order visits for mother as well. I've attempted to work that out off the docket with the petitioners and their attorney to no avail. There's simply, outside of Your Honor giving them clear instructions, there's simply no way to move this case forward. And I appreciate your assistance with that.
So going back and looking at the order extending filed on June 14, 24, there is an immediate order that says mother may have supervised visitation after enrolling in inpatient treatment as directed by the Department of Corrections and upon providing a clean urinalysis to counsel for petitioners prior to the visitation taking place within 24 hours and subject to any limitations imposed by the DOC and or the inpatient treatment facility into which mother enters by order of court in relation to her criminal matters. Supervised visits are to be no more than once a week, visits for 1 hour per week in a public location. Guardian ad litem Christina Day should be present at least the first visit and may be present thereafter at her direction. Counsel for mother will provide documentation to counsel for petitioners showing proof of mother's enrollment, participation, and treatment. And then Jack Carnahan acknowledged as bothered by the state of Washington shall have supervised visitation upon providing a clean UA to his attorney for forwarding to the attorney for petitioners with the UA to be conducted regularly to allow review for continued compliance as will be required for visits to continue. If the results of the UA show that use of any substance not prescribed legally by a doctor show up as positive, including if marijuana levels rise upward at any point above the levels of 5 or 5.1524, visitation shall not continue. Supervised visits will be once a week for 2 hours per visit in a public location. Leanne Couch will serve as a supervisor. If Leanne Couch is unable or unwilling to serve as supervisor, another supervisor shall be chosen and agreed upon by the parties. Guardian ad litem Christina Day should be present for at least the first visit and may be present thereafter at her discretion. Supervised visitation is conditional upon father's continued enrollment in substance abuse treatment. I read that to make sure the record is clear and everybody understands what it is that I ruled. So I want to ask, Mr. Forrest, if you're representing yourself, you have got to get a system that can be heard, because most of what I heard from you was garbled. So I could not understand what you were saying for the most part. I tried to figure it out based on the few words that I could understand. So that's one thing that you're going to have to do, is get a system that works. If I heard you correctly, I had the idea you were concerned about the UAs. I'm not sure if that's what you had indicated. And I understand I understand about the child and all that. I heard that part. So let me just follow up. Unfortunately, we don't have Mr. Agnostu, because I want to know whether or not council received clean UAs. Mr. Esau?
Yes, I did, Your Honor. I did not provide them to counsel, Ms. Cowden, because Ms. Day was doing that. And so I didn't want to duplicate efforts at this time. So, but yeah, so I failed to do so, but I thought I had a good reason, because they were already being provided by Ms. Day.
Okay. So Ms. Day, can you clarify as to the times of visitations were going on? Were they provided within the 24 hours?
They were provided within 24 hours of my receipt from the either treatment center, whichever treatment center, and I have to request those records every week. They don't just send them out automatically, and I provided them. The challenge with father's treatment is that they have to be done every week. With mother's, I've been able to get all of that at one time. She has completed treatment, and I did file that, as well as the clean UA.
Oh. So what I'm trying to clarify without pulling up records and looking into it is just looking at a clean UA to his attorney for forwarding to the attorney with UA to be conducted regularly to allow review for continued compliance. So it sounds like that's what's occurred.
Your Honor.
That has occurred, Your Honor. The challenge has been that the UAs done by community house are the traditional dipstick. Unless they show positive, they don't get sent back out. So that's why I had them provide a letter to indicate that, and I spoke with them directly. The UAs that are done by the treatment center, which are random, not done every week, they are random, those are provided upon receipt, and I request those every week.
So, Your Honor, can you hear me now?
I can.
I think the problem was I run off my laptop, but I had it closed. So we had received 7 UAs in a row from Ms. Day from the end of March until the 8th of May was the last one collected, and then they just stopped. The only thing we got after that was a drug screen, which showed no levels, and something from the Core Health that just said May compliant. So, like I said, the SUD supervisor at court says that they are only, like Ms. Day just said, that they are only random. So we don't know when the last time he was actually tested. The last UA that we saw any levels was from May 8th. And unless she's got something different, the only thing I have all of them right here. And
Okay,
the
well,
last
I don't,
one,
okay, I'm gonna just stop you right there. One thing, I have a limited docket here. I can't go through these things in detail, I've been struggling with hearing. I've been struggling with everything else going on. And unfortunately, Ms. Cowden, I don't know if you can at least respond to this. Have you received the UAs?
There's been inconsistency in the timeline in which we've received them. It hasn't been weekly. I've forwarded to my client everything I have received.
And as I indicated, Your Honor, the levels don't get run if the UA is clean. So if they do the dipstick and it's clean, they don't send it to the lab unless it shows positive. So that's why there are no more levels being provided, because there's not been a positive UA or any reason to do the levels by the provider. I can't instruct the provider to run the levels at my request. I can only provide the documentation the treatment center provides me.
And if I may, Your Honor, that was not communicated to us.
and the order was for a clean UA.
Not every week though, it was my understanding.
Okay. So here's what I'm going to do. One, I'm not changing anything yet. I've ruled what I've ruled, and I want it specifically followed. And if I need to do another order that shows, I understand where Mr. and Mrs. Force are at in regard to their concern, whether it rises to contempt or not, I don't know. But at the same time, if they're not receiving the UAs, what I don't have in here, let's see, clean UA. So if at the community house, Mr. Carnahan, I can't address you. Your attorney's not here. I'm sorry. He didn't have anybody else appear, and I don't feel like any of this. So at this point, I don't feel comfortable, one, that Mr. and Mrs. Force haven't heard a good part of what they've had to say. Secondly, I don't feel comfortable that Mr. Carnahan is essentially unrepresented, even though he's represented. And I'm not going to specifically, I can't talk to you, Mr. Carnahan. I apologize that Mr. Anagnostou didn't get, you know, I mean, that's on him. I don't know what to do. There's nothing I can do. And that Ms. Cowden, who has been representing, is suddenly not representing, and I'm hearing from Mr. and Mrs. Force. I want this cleaned up as far as who's doing what and having the attorneys present. This is important. And I've already ruled. I understand, Ms. Day, you were asking for additional, and that my concern at this point is in regard to this other supervisor. I want a supervisor. I'm not completely comfortable at this point that we just go without a supervisor yet. So if it can't be Ms. Couch as indicated, then it needs to be another supervisor. At the same time, Mr. and Mrs. Force, I expect you to follow. The parents have a right. I get your concerns. I agree with Ms. Day that the child is going to go through issues. It's going to be a part of reunification and seeing the parents. It's going to be, I'm not going to tell you that it's going to be a simple process. But this idea of hanging your hat on the idea that you're looking out for mental health and therefore not have visitation. I have a court order. I expect you to follow that court order and do exactly what I talked about. I expect everybody else to do exactly what I talked about and what I ordered. So I'm setting this. When is Mr. Anagnostou back?
I believe it's the week of the contempt hearing. I don't have that date in front of me.
Okay, so I'm not going to make any changes today. I want better system, Mr. Boris. I did hear you after you did whatever you did with the laptop. And Mr. Carnahan, got it. You need to reach out to Mr. Anagnostou's office. If he can't be here on that date, then they need to have somebody else present. Ms. Cowden, I'm assuming from the confusion or what's going on here is that you're withdrawing from the case. Is that my understanding?
That is correct.
Okay. So bottom line, I expect everyone to follow, and you're going to have to work out another supervisor, but that's not going to be a basis not to have the parents see their child. They have a right under the law to see their child. They're doing what they've been ordered to do. So I expect you to follow through. And if they provide the UAs as required, then I expect you to follow through with the visitation.
Your Honor, can you please clarify the UAs? Do you want them every week? Do they need to pay for them? Because that's where I think the confusion is. The petitioners expect clean UAs every week before visitation, and I simply cannot provide that from the providers who are doing the UAs. And that was not your order. So if that's what you're changing, I need to understand that.
Well, I can tell you that's what was submitted that everybody has signed off on.
That are supposed to be there every week, because this was specifically addressed at that hearing, not every week.
However, if the attorney's UN.
Just stop. With the UA to be conducted regularly to allow review for continued compliances will be required for visits to continue if the results of the UA show that use. So I'm not showing that it's every week. The one on for mom, it was a clean UA to counsel for petitioners prior to visitation taking place within 24 hours and subject to any limitations imposed by DOC. So I don't know how often DOC is doing their UAs. Mr. Esau, do you know?
I believe it's I would have to defer to my client, but I believe it's only when she goes in to meet with her probation counselor. She's raising her hand to speak.
So I'm not going to do this. I am now at 11:42 and I have all these other people that have been waiting. I expect the UAs to be weekly. I don't expect them within 24 hours at this time. They're supervised visits. And I expect the bourses to follow through when you're provided that UA. I expect you to follow through with the visitation. If you can't agree on a supervised visitation, I'm going to have Ms. Day make the decision because I want that visitation to continue.
We had decided I'm on the form.
All right.
Okay.
That's it for that matter.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
It'll be over on the next.
The contempt hearing on the Tuesday. Okay.
Oh, the contempt matter got set on in front of Judge Basher. So what date is that?
July 9th.
Okay. All right. So we're going to set it over to the 11th, the contempt. All right. That's it.
Thank you, Your Honor.
Thank you, Your Honor.
Good morning, Your Honor. Donald Lisa on behalf of Katrina Vorst, the mother.
Cordan Ignacio on behalf of Jack Carnahan, the father.
Tina Day, guardian ad litem.
Mike and Carla Vorst, guardian.
Casey Looney on behalf of the state as to child support owner.
Okay. All right. So this matter comes on in part because the last time we were here, there were technical issues. There were issues about who was going to be doing what. And overall, and then I found out apparently there were several documents that I had not seen before going on the bench. So I did not have the opportunity to review everything prior to actually hearing argument on the motions. Because of that, that the court found it only appropriate to have it come back and properly heard. That said, I did want to inquire, hold on just a second. On June 21, there's a petition to terminate that was filed by Mr. Force. And I don't know if one, it was not signed off by the other guardian, which is Carla Vorse. So I don't know. Let me hear from the forces first about that matter. I think it's set on for next Tuesday, but I just need to find out if that's the intent, is to terminate this guardianship.
As long as there is visitation, it is, because she is a total emotional wreck. Even though the doctors have said, her doctor and the psychologist have said, visitation is not okay for this baby at this time. Sometime, but not now. And for some reason, the guardian ad litem just ignores that. We have a screaming baby. She's potty trained. She no longer goes to the bathroom anymore. She screams, she spits food. She has not been like that in 7 months. It's very, very hard. She's never once mentioned mom or dad, never once. But something is going on with that baby.
So one, I can tell you that the petition is only signed by Mr. Force. So if it's the intent of both of you to terminate the guardianship, which is your right, then Mr. Force can't act on your behalf, just so you understand that.
Yes.
So it needs to be signed off by both parties.
As long as it's visitations, we just can't handle it. I mean, this family.
I don't want to get into the whole thing. I'm just trying to find out if you're terminating. The whole point of minor guardianship is the intent to reunite a child. So I'm not going to tell you that whether now or in the future or whatever it may be, I don't know, is that the whole point is to reunite the child with the parents. So I need to understand that.
I understand that. I just worry about the relapses and the possible fact that Katie's going to be going to prison for federal fraud. She applied for.
I'm just going to stop you there. I don't want to get into all of this. I just wanted to clarify whether or not you intend to terminate. And if you do, one, it only is signed off by Michael Force. It's not signed off by Carla Force. So just to identify that one issue that I saw, but I didn't know if others were familiar with that motion being filed and on for Tuesday, because whether service was made of that or not, I couldn't tell.
Yes.
I question whether or not we go forward today or whether or not we wait and see if it's terminated.
I mean, it can be terminated now. It's very hard to handle a baby that is out of control.
Your Honor, if I may.
Go ahead.
So my motion was to increase visits because my client was getting very limited visits over. He lives at the community house, drug-free environment, and he's getting very limited once-a-week visits. And so we brought a motion to increase his residential time, and we complained about what happened on some of the past visits. But that aside, if the Vorses are going to terminate, this is a golden opportunity to transition Jessica into my client's residence. There was a parentage action in Cowlitz County, and if the court wants that number, I can provide that to you. My client under that parentage action is the residential parent of the child, of Jessica. And so she would be returned to his primary care, and then Katrina, the mother, can bring whatever action she wants in that action to set up visitation. Mr. Esau, of course, is representing her, but going forward today, we have a motion to terminate next week. This is an opportunity to transition Jessica back into my client's residence at the community house.
Counsel, Mr. Esau.
Thank you, Your Honor. I concur with Mr. Anagnostou, and I'm not sure about the parenting plan situation because I haven't seen that yet. But I I would, certainly not object if I don't have a basis. Anyway, the visitations with my client have been going well since she's been back from treatment, inpatient treatment. I talked to Mr. Vorse about this case a couple of weeks ago, I think, before the holiday, and he indicated he was going to terminate. But then the paperwork that I received by email, which was okay with me, I would accept that, indicated that they were asking to resign as the temporary emergency guardianship. So I'm not sure what they're asking for. Their words say that they want termination because they can't handle the baby. I understand, but their written word says they just want to resign, and I'm not sure if it's their intent for somebody else to take their place and somebody else to be appointed as guardian, or to just take it back to the parents. My client, I haven't had a chance to talk to her about this issue today because I knew we were going to be on for next Tuesday. But if I had to guess, I would say that she'd probably want termination and custody of, well, apparently there's an order saying the parenting plan says that it goes to Jack. But yeah, they could work that out later. But yeah, that's what I think my client's position. My client is raising her hand. Apparently she would like to add some information. It's probably information I don't have yet.
So I would ask, Ms. Forrest, you have an attorney, you need to communicate with your attorney somehow. So here's where I look at these. When I've terminated guardianships before, I don't have any authority over the parents as far as who gets that child after a guardianship. There's no active, once it's terminated, it reverts back to whatever case, our custody case, and it's up to the parents to determine or pursue that if that's what they are going to do. But as far as the idea that I'm going to then have the child go with Katrina Force, I'm not aware of anything within the statute, and I'll go back and look at the statute to see if there's anything upon termination. And maybe it's there and maybe they did put it in there, but if there's a parenting plan that's in place at this point, then to me, that would be the overseeing order that would be there. But I'll go back and look at the as far as what happens between the parents.
Right. If I could clarify, Your Honor. So there was a parentage action. I have the number here, but there isn't a parenting plan. It says the child will live with, and then it names my client, and then it indicates that a parenting plan was going to be filed. But as far as I know, one wasn't. So it's just the base order that says my client is the custodian of the child, and an indication there would be a parenting plan. But as far as I know, there wasn't.
Your Honor.
Go ahead.
So the original emergency guardianship was taking Jessica from Katrina, and that's how it was actually read, because of her drug addiction. In fact, that's how the order I asked you to sign was because of her drug addiction, and she was going to jail. So now that both of those were complete, as far as the emergency guardianship order that was originally granted, those were the reasons.
Okay. All right. So right now there is visitation in place. I know, Mr. Anagnosti, you were asking for expanded, but it seems like if it's going to move forward on the termination, then it seems rather doesn't make a lot of sense to work on a visitation plan in a case that's going to be terminated.
Well, if it's going to be terminated next week, we just want the child transitioned to my client at some point. I mean, is it going to be immediately following the hearing then? I mean, that's, I guess, would be good. It just seems between now and then we have this opportunity to set up some kind of transition.
So that's where I want.
Your Honor, this is Tina Day.
Yeah, go ahead.
Thank you, Your Honor. It is my understanding from what the divorces have said in the petition to terminate the minor guardianship and their statements today that they do want to terminate the guardianship. I would propose to the court that a transition makes the most sense. We're talking about a very young child. She has had 14 hours of visits with her father, and she has had 3 hours of visits with her mother. The parents work together very well, and I don't think that there's any reason that they can't resolve a visitation plan between the two of them moving forward. But I think to leave this child in a situation where this is all going to just be dropped next week is a little bit concerning. I again, though, the court has no control over the petitioners. If they wish to step out, then this child needs to be returned to her parents. And it would be my recommendation today that would be to Jack, because he's had the most time clean and sober, the most time with the child, and Jack and Katrina can work out how they want to resolve their visitation issues between the two of them. They both have stable housing at this time. They both have housing that accommodates the child. They both have good communication with each other and are able to co-parent this child. And I think that is the appropriate decision if the petitioners want out. This child needs some stability and consistency, and does not be in a situation where she is subjected to the kind of conflict that's going on currently.
So here's the first thing that needs to get done is the petition to terminate needs to be amended, or needs a new amendment that includes the signatures of both parties, both Mr. and Mrs. Force, because the one that was filed is only signed off by Michael Force. So procedurally, that's the first thing that needs to happen. Second, if there's a parenting plan that kicks in, and that parenting plan needs to get filed or something to show who has primary care. From what Mr. Anagnostou says, it's his client, and I don't have doubts of what he says. I just think a record needs to be made, and then a transition plan, the Forces returning the child to the father, if that's the case. And then it's between the parents as to what happens from there under their parentage case.
So, Your Honor, do we just need to go to the courthouse and have her sign that order?
No, because it's already been filed. You'll have to print out a new one and just both sign it. You can put the exact same information, just need to both sign it.
Okay.
I'm looking at least a copy that I have. It has Carla Vorse's signature on it. It's basically the very last page, the page before that. So they signed on separate pages.
Oh, let me look again. Maybe I didn't look far. You're right, Mr. Anagnostou. I did not look
I hadn't either.
far enough. I apologize. Yes, it is correct, Mr. Force. I didn't go down far enough. I just went to what I thought was the last page.
Right, me too.
So then, Your Honor, can we have a ruling from you on how to transition between now and next week?
Okay. So I just need to confirm, I don't want all the side information. Michael Force, are you wanting to terminate?
Yes.
Carla Force, are you wanting to terminate?
Yes.
Okay.
I would like to say that if there is a problem and there is a relapse, we are here for that baby again. Katie is our niece. We care about these people.
Thank you. So, Mr. Anagnostou, is there a way that you can scan real quick, or tell me the cause number?
Oh, sure. And that's the public record following the confidential paternity part of the action.
Okay. I'm going to pull that up here.
We could take her to where Katie is today, this afternoon, if you wanted.
Okay, just a second. I just want to confirm everything before I make any kind of. Mr. Anagnostou, is there another number? Because this is just the
order granting summary judgment has the most recent order.
Okay.
Parents are supposed to include that case order.
So I just have a summary judgment order for parentage as the final order. I don't have a parenting plan in that cause number that you gave me.
Correct. And so it's paragraph 8.
And let me look here.
Which indicates that they in the future can file a parenting plan or residential schedule. And then below it, the box checked is that, but I don't think one was ever filed.
It's not, at least not in this case, if they have another case somewhere.
So basically placement under this order is with my client.
What did you say?
Said it's not in the parentage action. Once we convert it to the 3 case, then the parents are supposed to move it forward for final.
Yeah. Yeah, the parenting plan wouldn't be in this.
Right.
So that's what I know at this point. Very limited information. And so, Mr. Issa, are you good with that? I mean, that's the order that I have at this point. Are you good that the child goes to dad?
Well, I don't know because I haven't asked my client.
Okay.
So I think, I mean, obviously the order says that it goes to dad. So I don't have a position at this point until I talk to my client.
Okay. Well, again, I'm limited to what's ordered at this point since I don't have any authority over the 2 other than, especially when I have a court order that tells me that. So with that in mind, Ms. Day, anything that you can tell me, you kind of did, but just go ahead to confirm any concerns at this point in regard to the child going to dad's.
I don't have any significant concerns with the child being placed with the father or the mother. They both have demonstrated their ability, although they were late to participate. They have both been very consistent since then. Father has the substantial time, and my understanding and my reading of that order is that he is the residential parent. My understanding from contact with both the parents is they are working together and can co-parent. So I'm certain that they will come up with a plan that works for both of them and for Jessica. I think it's appropriate to dismiss the action and allow the parents to be the parents.
So here's what I'm going to do. First off, anything else from anyone?
Nothing further.
So what I'm going to do is I'm going to sign off on an order terminating. And then I will go ahead and identify that the child will be, I don't know, Mr. Borse, you said something about transporting or bringing. I wasn't quite sure what you said.
Well, I just said we could bring her things and do it tonight if you want.
Okay. Mr. Anagnostou, is there a time that works for your client?
Any time that is convenient for the Vorses.
Okay, Mr. Borse, what's a good time?
Well, we pick her up from, we can pick her up from daycare anytime after 2, actually, so. And in fact, it would probably be good that they come over and sign up as the people to pick her up and to drop her off to use daycare.
They have to
I know. But we can do that where we can sign them on as the,
they have to reapply.
yeah, but we can sign you right now to be able to pick up from daycare. So if you want to meet me there at 3:00 this afternoon or something, that would be.
3 p.m. I'm sorry, which daycare?
It's over.
That they will have to reapply for that.
Yeah.
All right. All right. I just want to confirm anything further from you, Ms. Looney, at this point.
No, Your Honor, with the child's return to the parents, there's no interest in child support from the state.
Okay. All right. So we'll go ahead and I'll sign an order terminating, placing the child with the father, and exchange 3 p.m. at the week here at Catlin. And that would strike the hearing from next Tuesday. So with that, is there anything else that anyone can think of at the moment?
we're going to strike the trial date also from September 30th, right?
Correct. That will happen. Correct.
And the other motions for the contempt and the extended hearing are gone as well.
Yeah, I'll just, counsel, I'm just going to strike those. The matter is going to be dismissed, or terminated. So nothing further on those. I just want to encourage the parents that this child needs clean and sober parents. They need parents that are willing and able to parent this child in a healthy and good way. And, when we have litigation that goes on, lots of emotions can happen. And with lots of emotions happening, I ask that you look to move forward and look to the best interests of this child and see that she has the happy, healthy life that she needs. Okay. All right. Anything else?
No, Your Honor. Thank you.
All right. That concludes this matter.
Thank you, Your Honor.
Thank you, Your Honor.